Welcome to Pony Radio. I'm your host, Pascal. With me, as always, is Tristan.
Hello!
And we're very pleased to have our guest today, Professor Reisinger.
How do you do?
He's going to talk to us about evidence. And, we should probably take a call and get right into it.
Sure, it's starting off right away with first caller, and you're on the line, caller. Welcome to Pony Radio. What's your question today?
I have been watching a lot of court shows on TV, and they always throw around the phrase, I object.
I object!
Is that what lawyers really
Love
say?
saying that.
They just get up and yell, I object, without anything more?
Well, they do say it. They may not always yell it. Some yell it.
That's the most fun way to do it.
Well, it might be the most fun way to do it.
Yes.
But it's not necessarily the most effective way to do it. It depends on how the jury would react to that. Now, the reason lawyers get up and say, I object, Tristan, is because they're saying that something that the other lawyer is trying to put in front of the jury is something the rules say should not be in front of the jury. And that's when they say it, whether they yell it or not.
Interesting. So, where do those rules come from?
Well, the rules originally were made by judges in the course of trying cases, but now the rules have been collected and written down in the form of a set of rules that have been given out in most American jurisdictions, not every state, but in most, given out by either the court or the legislature so that everybody knows what the rules are and everybody is on the same page. And of course, it's not enough to say I object.
No, of course not.
No, you've got to say why you object.
Exactly.
That's right. Now, how would you do that?
I would say, I object, and it's because of that bad thing that just happened.
I know many lawyers whose style of objecting is not much more specific than that.
Yes.
Unfortunately, the rules in most places say that you have to have a ground for the objection, and that means you have to know a little bit more than the fact that you don't like what just happened in order to be able to have the objection count and the judge take it seriously.
So it's like, I object. And the judge says, well, why? And I say, because of this ground I'm standing on.
Exactly. And then you have to know what ground you're standing on. Now, if you look down now, you can see it. But if it's carpeted. But if it's a question of evidence law, then you don't look down, you look in the rule book. But you don't have time to look in the rule book. So you got to know it. You've got to be able to remember it right then.
There's a lot of different things to remember.
Oh, yes, there are.
Like Mother's birthday.
Right.
I'm sorry, Mother's birthday's tomorrow.
Oh, yes. Well,
remember
don't forget that. But it's more important if you're in a trial to remember the grounds for objection than it is, well, it can't be more important than your mother's birthday, but it's equally important.
Yes, well, thank you. And I hope that answered your question, caller.